Modern real estate practice, page 154. In practice, the general discussion here involves the concepts and principles that govern traditional common law agency relationships. Many states have passed agency legislation that supersedes the common law of agency. Many agency statutes make the common law duties a matter of statutory law rather than or in addition to creating totally new legal relationships. While we are providing an overview of current agency laws, a real estate professional should be familiar with the specific terms of any agency statute adopted by the legislature of the state in which the real estate professional does business. The websites listed in the appendix provide access to statutory law as well as the rules and regulations of each state's real estate licensing agency. In what is termed a single agency relationship, the agent represents only one of the parties to a transaction, and there is a distinction between the level of services that the agent provides to the client. The agent represents and those services that the agent provides to the other party who is the customer. The client is the principal to whom the agent gives advice and counsel. The agent is entrusted with certain confidential information and has fiduciary responsibilities discussed in greater detail later. To the principal, the client can expect full disclosure of all relevant information learned by the agent. In contrast, the customer is entitled to factual information and fair and honest dealings as a consumer, but does not receive advice and counsel or have an expectation that information disclosed to the agent will remain confidential. The agent works for the principal with the customer. This means that the agent supports and defends the principal's interests, not the customer's. The relationship between the principal and agent must be consensual. That is, the principal delegates authority and the agent consents to act. The parties must agree to form the relationship. Just as the agent owes certain duties to the principal has responsibilities toward the agent. The principal's primary duties are to comply with the agency agreement and cooperate with the reasonable expectations of the agent. That is, the principal must not hinder the agent and must deal with the agent in good faith. The principal also must compensate the agent according to the terms of the agency agreement. Creation of agency. Later, you will learn about the legal requirements to create a contractual relationship, along with description of the varieties of contracts that are part of a real estate transaction. Here, some of the elements of an agreement to create an agency relationship are discussed. An agency relationship may be created by an oral or written agreement between the parties, which is an express agency. An agency relationship may also result from the parties' behavior by an implied agency. Express agency. The principal and the agent may enter into a contract or an express agreement in which the parties formally express their intention to establish an agency and state its terms and conditions. The agreement may be either oral or written unless, page 155, a written agreement is required by law. The employment agreement of broker and sales associate must be in writing. An agency relationship between a real estate seller and a broker is generally created by a written employment contract, commonly called a listing agreement, seller representation agreement, which authorizes the broker to find a buyer or a tenant for the owner's property. Although a written listing agreement is usually preferred, some states consider an oral agreement binding in some circumstances. Although an exclusive representation agreement must be in writing in order to be enforced in court. An express agency relationship between a buyer and a broker is created by a buyer representation agreement. Similar to a listing agreement, The buyer representation agreement stipulates the activities and responsibilities the buyer expects from the broker in finding the appropriate property for purchase or rent. Implied agency. An agency may also be created by implied agreement. This occurs when the parties act as though they have mutually consented to an agency, even if they have not entered into a formal agency agreement. While neither the real estate professional nor the represented party may have consciously planned to create an agency relationship, they can create one unintentionally, inadvertently, or accidentally by their actions. If this existence of an agency relationship becomes the focus of a legal action, the real estate professional may be in lose-lose position. If an agency relationship can be shown to have been intended, legal responsibilities may be imposed on the real estate professional, even in the absence of a written agency agreement. The real estate professional may also be denied compensation on the grounds that there is no written agreement as required by law. In practice, prospective buyers enter into a real estate office asking to see a property listed with another brokerage. A real estate sales associate immediately calls the seller's representative and makes an appointment to show the property. Without having the prospective buyer sign a written representation agreement, the sales associate drives them to the house. The intent of the parties to create an agency relationship can be inferred from the actions of the sales associate. Even though real estate professionals might be required to disclose their agency status, consumers often find it difficult to understand the complexities of the law of agency. Buyers can easily assume that when they contract a real estate sales associate in order to be shown a property, the real estate sales associate becomes their agent, even though under the listing contract on the property, the real estate sales associate, through the broker, legally represents the seller. An implied agency with the buyer can result if the words and conduct of the sales associate do not dispel this assumption, which may lead to the creation of an illegal, undisclosed dual agency, discussed later. Some states prohibit the creation of agency implied by conduct. Compensation. In a real estate transaction, the source of compensation does not determine agency. An agent does not necessarily represent the person who pays the agent's commission. In fact, agency can exist even if no fee is involved, called a gratuitous agency.